get to actually look at you. Sorry about that. So, how's everybody feeling? Have we got any questions? Anywhere we want to start? Everybody's being shy. Okay, or I'm not looking at the chat properly. See, you can't hear anything clearly, and I'm dropping in or out. Let's see if I can fix that. Is that a universal problem that people are having trouble with hearing me?
No, I can hear you fine, Kath.
I can hear you, but you were cutting in and out.
Okay, I'll just say, like I said, I am trying some new software that is designed to mute background noise. And those AI things, they're terrible with women's voices. I've just turned it off. Is that better?
Yes.
Noticeably better, noticeably worse? Okay. All right, it's always good to know if the software doesn't work, then we don't use it. Questions? Anything in particular anybody would like to start with before we launch in and do a problem?
I have a question.
That's the one we want. Share. Okay, my guess is I won't be able to see at the moment if you have comments. So, so you'll need to use your voices. Okay, so this is our problem. Pretty straightforward. Before we get too stuck in, so most of you, actually just looking, yeah, I think most of the people who are here today actually did have a go at the problem. And so you should have had some feedback from me today. It won't usually take me this long, but for reasons I won't bore you with, it was just a particularly busy week, and usually I should be able to get them done on Tuesdays. But I had to write your exam, and it took me ages, and I suffered terribly while I was doing it, for what it's worth. So you can remember that when you're suffering doing it. Okay, so these kind of problems, it is really good to start at the beginning with actually being really clear on what being asked to do. So there are lots of different issues that we could pick up along the way here, but ultimately this is what our problem is. We need to advise our client, who happens to be Zita, let me hide that away, happens to be Zita. We've got to think about what legal rights Zita has. So pulling that back into plain language, Zita got an email offering her a kitten for a price. Her version of this story is she has accepted that offer, but before the offer, she even accepted the offer, the kitten itself had been sold to someone else. So start by being really clear on what you're trying to answer. So we're not here counselling Zita about kittens generally. We're not suggesting she gets a puppy. We're not going to talk about the terrible problems that there are with pet shops. We're limiting ourselves to the legal issues. And when we look at this problem, we've got to unpick, well, what the legal issues are. Now, you've always got a couple of head starts while you're at law school. We know, because of the context that you're doing this in, that this is a contract law problem. We also know, because it's the end of week 2 when you were being asked to do it, that it's likely to relate to the making of an agreement, offer and acceptance. And you'll see this as they fall across the course of the semester. Of course, once you get to the exam, the problems could relate to any part of the semester. So you don't have that clue anymore. And to a certain extent, some of the problems you'll find in these discussion board tasks, some of them will sit slightly ahead of us doing the subject matter in class. They're designed to get you thinking about where the issues might be. So I have a pretty straightforward way of identifying the issues. As you can probably see from, actually, the way my camera is produced today, you can't see. Usually my walls are covered in Post-it notes. I use post-it notes to solve problems all the time, and I do that with virtual post-it notes as well. So one of the first things that I do is actually pull out, well, what might be relevant here. Now, the approach we've been taking is IRAC. So we're taking, identify what the issues are, articulate what the relevant rules are, apply those rules to get to a tentative conclusion. In order to identify what the issues are, we need to work out which facts are relevant. Now, the tricky thing about issues is they arise in two ways. One, they just fall out of the facts. So if we're going to take a really high level view, we've got the question here, or the issue, is there a contract? Because we have a client who believes that she has the right to pay $500 and get a kitten. So that just falls straight out of the facts. But some of the potential issues are likely to come out of the way that the law works. So it's not always as simple as just, if we work out what all of the facts are, we'll see all of the issues. It might be, we work out what the law is, and then we have to cycle back to work out whether there are issues as well. And in this problem, there's one potential issue that comes out that way. So what I like to do at the beginning is, I'm using color coding. You could just write this down in 3 different columns is often a good way to do it. And I see that often in exams. I'll see people using the other side of the page for their plan, and they will work out what the relevant facts are, and then they will write down 2 other things. So I've kind of color coded it here. They'll work out what assumptions you have. Sorry, I'm not quite sure why I can't see my controls in order to create the pen here. So I'm here using green to basically say these are what my assumptions are. And then I've got some questions or further information that I might need. Now, my experience as a lawyer is that your clients very rarely tell you everything without being asked questions along the way. And one of the things that those of you who've already done taught will have done the practice aspects, I can never say that quickly, practice aspects of the JD. Terrible name. But that's basically the fake interviews. So where you get the basis of a scenario, but then you go through the process of getting more information. And when you're preparing for those interviews, you are doing exactly this. You are thinking, what might I not already know? What assumptions am I making that I need to test? So once I've got all that out, really the next thing that I do, so we've got the facts. The next thing, I want to make sense of the facts. And so I find putting together a kind of timeline is a good way to do that. So here, again, this is why I like the post-it notes, because I can just move them around. She says not being able to move them around. Come on, stupid software. Okay, so if I do this, I can say, okay, and off, let's get them in the right order. So at 9 a.m., Susannah sent an email to Zita offering to sell the cat for $500. I'm going to make the top half of the line stuff that Susannah did. The offer stated that she needs a reply within 24 hours. Now I'm putting that in. I might not have thought about that the first time round. I've just done this problem a number of times. It might be something that I came back to as I filled out the facts, because ultimately that statement, I need to know within 24 hours, we have to ask ourselves, is there an implied promise there that she'll keep the offer open for 24 hours? There are also some assumptions that we might make about this email up front. The way that that problem was worded, it actually used the word offer in it. So it's perfectly reasonable for you to assume that the offer was a legal offer. But we all now know that there are lots of bits of conduct that ordinary people do every day, where they may think that they are offering things for sale, but in fact, they're not doing that. What are they doing?
Intent to treat.
Yeah, an invitation to treat. So many times there'll be an invitation to treat. So again, this could be something that I'm going to ask myself at this point. So let me get a sticky note up. What color are my assumptions? Okay, I'm going to assume here. Excuse my spelling. Or my typing. So I'm going to assume it's not an invitation to treat. Now, we don't actually have that information. We're going to assume, I think it's perfectly reasonable for you to assume some sort of backstory. Zita and Susannah know each other. Susannah sends an email saying, I've got the kind of kitten that you want. You can have it for $500. It's yours. And that would be an offer. But she might have actually sent an email to all of her customers saying, we've now got a litter of kittens, or we've got a kitten in the store. I'll need to know who within 24 hours if anybody's interested. We don't know that. We've got no way of knowing what the answer to that is at all. So that informs us of what questions to ask when we're meeting with our client, right? So very few people actually, when they were doing it this time around, raise that issue or the potential for that issue. But again, can you see how it's just by looking, being logical about the facts, being really clear on, well, what am I assuming here and what am I not assuming? If I make an assumption, I need to think about, well, what will happen if my assumption is not true? And how will I find out if my assumption is or is not true? Now, they're not big deals with these kind of problems, but when you're doing the main assignment, the assignment that I released a problem for last week, or it's first day of this week, the one I released last Tuesday, you will need to be thinking about what assumptions you're making, and you'll need to articulate what the consequence of making that assumption is. I mean, if nothing turns on it, and there are a couple of assumptions here. So, for example, I have made an assumption that Zita still wants to buy the cat. I think that's a reasonable assumption to make in the circumstances, but I don't think anything actually turns on that. I don't really need to, other than Zita's not interested in our advice if she doesn't care. Nothing really turns on that. So in identifying what assumptions there are, then you're thinking through, well, if something turns on it, if the answer would be different if that assumption was incorrect, then I need to do something about that. I need to make a note to ask my client to confirm that the assumption is true. So then what happened? At Friday at 12, Zita opened the email. So let's put that at the beginning of Friday afternoon. Sometime later that afternoon, Susannah sold the cat to somebody else. Let me just make that a little bit bigger so I can see what's going on, or you can see what's going on. Almost immediately after that, she sent an email revoking the offer. So they sort of sit almost at the same place. So I'm going to move Zita down there. Let's make the bottom of the lines the things that Zita did, just so we can see how it falls. Sometime later in that afternoon, Zita then sent an email telling Susannah that she wanted the cat. 10 a.m. Saturday, oh, actually 8 a.m. Saturday, Susannah saw the acceptance. And later on that day, Zita read the email with the revocation. Let me get that into the, okay. So can you see how it's useful to push it out into a timeline? Now, for a little simple problem like this, you're probably over-egging the pudding by getting out your Post-it notes and your coloured pens, to be perfectly frank. But it's not a bad discipline to get in, to start using. And when I say discipline, it might not necessarily be this. For some of you, it'll be just writing everything out in a list, using 3 columns. What are the facts? What are the assumptions I'm making? What questions do I need to ask? So from there, what what assumptions do I want to list in here? Another question that I had here is, I'd need to read the email to know whether that 24-hour period, where does it start from the time that the email gets sent out, or does it get sent out, does it start from the time that the email is read? Now that question itself, I think the law is going to help us with that, and the better answer is probably over here, and that's because of the way the electronic communications work. But again, I don't think anything very much turns on that particular question. It's going back to, it's not a bad thing to have too many questions and then to work out that they're relevant. That is much, much better than not having enough, not going deeply enough. So the next thing that I do is try and identify what the issues are. Now, I think you can find more than this. One of the things comments that I made on a number of people's papers with this one is the people were very good at identifying what the potential legal issues were, but not so good at telling me why they mattered. So we've got Zita here. You've been asked to advise Zita. There's nothing in the facts that would suggest that Zita is a lawyer. I don't know that it would really matter anyway. But what we're really trying to do here, what she really wants to know is, can I bring some sort of action so that I can get that cat? Yeah? So in going to the next stage, what happens is we tend to go too deep early on. You say, okay, what we need to do is work out whether or not there was an offer, and if that offer was accepted, and if the acceptance was communicated. And then people tend not to say, because if we have all of those things, we have an agreement, and if there's an agreement, then she will have legal rights. And sort of, it's kind of so obvious it goes without saying, only it doesn't go without saying. You need to answer that question. So what kind of things have I got in here? So the one that's missing is there an agreement? Having told you off, or not told you off, but highlighted the point, I haven't articulated that either. So let's start. Can you see how there's value in just articulating a range of different issues? And just looking at them, a couple of things I'd like to point out. Let me just make that a little bit bigger. This one we saw a lot. That's supposed to be a tick. This one I saw a lot. This one I saw a few times, but not very many. So that question about whether or not there was whether or not there was an option or whether it was binding. Actually, I didn't see that one at all. Didn't see that one at all. Saw this a couple of times. Sorry, this is our key overriding issue, which I thought I hadn't put into that list. If there's an offer, was it on foot when it was accepted? Now, again, most of you address that in some way, but a few of you are a little bit clumsy and wordy around getting there. Another way of saying that is this: was the offer accepted before it was rejected? They're similar, if not the same thing. Two parts again in relation to revocation. Was the revocation properly done? And if so, was it communicated? They're two sides of the same coin. We don't have any details of the words that were used. The problem itself uses the word revocation, which is the technical expression. So I think it's absolutely perfectly reasonable to assume that it was properly revoked. But the question became, has that been communicated? Because that goes to whether or not the offer was still open or not. Similarly, was acceptance communicated? Was sending a fax an appropriate way of communicating acceptance? And if it was, was it communicated? and when was it? Was it at the time that the fax was sent or at the time that the fax was read? So again, few other potential little issues in there. For example, in relation to this, that might have been worded slightly differently to refer to options. So I don't think anybody used the option terminology from memory, but a number of you referred to the key case, the options case. Goldsboro Quinn, Goldsboro Mort and Quinn, I should say. And so I know a number of you picked up this issue. So again, we can pull those up against our timeline. So yeah, let me just do that. So I need to just get back over here. So again, useful to do this. Think about it in terms of who the parties are, when was it accepted. So pulling the data in. When was the revocation? At what point is it is it effective? Can you see what I'm doing? And we can just pull together as much of the data as we can. So that's thinking about issues. The next thing you need to do is match your issues with your rules. So the trick in relation to the rules, and again, I'm going to show you the key ones here. Hopefully it'll all be on the screen. The key things that were really important. This software doesn't let me reference format referencing properly. So, you know, for these things, don't worry about that too much. But again, having said that, particularly for you face-to-face students, this is all about feedback. So I will give you feedback if I notice your referencing is not in the proper format. I also, if you've noticed, for those of you who are face-to-face, you just get something that says it's complete or incomplete. It doesn't actually give you a mark as such. In fact, I think when they're complete, they just automatically go to 25 out of 25. You'll feel like a hero. But if you look in the rubric, you can see the mark that you would have got if you were doing it for marks. So, and you can get a sense, basically if you multiply the number by 4, you'll get a sense of whether you got a credit or a pass or a fail or whatever. So, okay, so really these are the key rules for this case. Some of, again, are more important than others. The trick, this is a long-winded way of saying this, the trick is if you cite or refer to a rule, I want you to give me a citation. So on the whole, I find that students who come from science backgrounds are often much better at this than you arty people, because you know that when you write a paper in science, that if you refer to a fact, you need to support that fact with evidence, with data, and you give weight to primary data over secondary data. The fact that there is a rule is the fact. So every time you refer to a fact, like the rule, you want to support that. This rule exists from where? Which case? Now, a number of you use the textbook as your data source. Sometimes that might be the only place you've got to go. There are some principles that even our textbook doesn't tell us where they come from. But it's pretty rare. Almost every statement that we make about the law will come from something. Even so, tomorrow night we'll be talking about consideration, and it's likely that at some point, whether it's tomorrow night or the following week, we'll talk about Pinnell's case, which is a case that effectively says that if I promise you that I will release you from your obligation to pay me some money that you already owe me, in exchange for your promise to pay part of that amount, that in fact your payment of that part payment will not be sufficient consideration for my promise to waive the debt. So I effectively require you to make a part payment, and I can still chase you for the rest. We'll talk about that in some detail. The reason for noting this is that rule comes from Pinnell's case. Pinnell's case is so old that we actually get that rule from a case, the name of which is escaping me at the moment, Folks and Deer, I think, that actually cites it 100 years later. Pinnell's case itself was decided in Latin. That's how old it is. I think that's one of the oldest ones that we do. So sometimes you won't be able to get to the primary source, but if you can, a primary source carries more weight than a secondary source. Now, I'm not an idiot. I know that you haven't actually pulled out the original cases and read them all. I know that you're working with the extracts in your casebook or the footnotes in your casebook, but that's okay. I need you to know which cases support the theory. So it is better for you to put a case there than it is for you to put a secondary thing. The other thing that came up with this question a number of times is, and this was a bit of a trick for young players, is the Transactions Act, the Electronic Transactions Act. Sorry, let me find my pen again. There we go. Now, the thing is, this is, oh God, that is the most ridiculous shape I've ever done. It looks like an eye, and I wouldn't really know what an eye looks like. I don't use them myself. The thing, this was a little bit tricky for most of you because what it says in our materials, it just refers to the Commonwealth legislation. It doesn't actually refer to the state-based acts. So it does actually require you to do a little bit of reading. So I think actually the state-based act might be in your casebook, but generally the discussion about the Electronic Transactions Act in the text refers to the Commonwealth legislation. And actually the Commonwealth legislation talks about if you need to do something as a consequence of the way a Commonwealth law operates, it talks about what will happen if you do it by email, or if it needs to be in writing, can you record it electronically? So that's actually not relevant to what we're looking at here. This is a standard contract provision. So again, a few of you made the assumption that this happened in Victoria somewhere. You could have assumed it was somewhere else, but generally good assumption. This is a law school in Victoria, so we teach you the Victorian law. And so it's actually the Electronic Transactions Victoria Act 2000. Another thing that's odd about this act, it's a really funny citation. Most Victorian legislation it would have taken the format Electronic Transactions Act 2000 bracket Vic close bracket, but this particular piece of legislation has Victoria in its name. So again, they're tiny little tricks for young players. I don't really penalise anybody for not noticing them. It's a good opportunity for you to point out that that attention to detail can be the difference between a distinction and a high distinction. Like those kind of points are not going to make any difference between a credit and a pass, really. But if you're sitting there at a distinction, it's harder for me to justify putting you in the high distinction category if you're not paying attention to those tiny little details. So again, what I would do in my physical space is I would be matching these things along the timeline. So again, over here, I would be saying, okay, I need to identify whether there is a contract or not. In fact, let me do that here. And the reason I need to identify, oh, sorry, I brought the wrong one over because I can't see that tiny print and neither can you. Let me just move that. Let me make this bigger. My first real issue is there a contract? Because if there is, then she might have some rights. If there is no contract, then it's too bad, so sad. In order to work out whether there's a contract, we apply an objective test. We look at what it is that the parties did, not necessarily, and what would be understood by those actions by an interested bystander having the same information. Now, I've been lazy there. I've thrown Carl Hill and Carbolic Smokeball in as my citation. There are plenty of others that I might have used there, and probably Taylor and Johnson on the objectivity point is a better case in Australia, more modern Australian law. So, but again, pick what your cases are. And as I go through each of the facts, I can match my issues with them and then match the rule with them. And then I start to see how it applies. So in short, what happened here, and by the way, I'm kind of trusting you guys to interrupt me and ask questions or disagree with me or fight, whatever you want to do. In short, basically what happened in this case is, let's assume, and we don't have to, but let's assume that it was a direct email from one person to another. I'm Susannah. I'm offering you, Zita, the opportunity to buy this kitten. That the offer was clear. It contained all of the DNA of the deal. It was capable of being accepted on its face. It said, I will hold this, well, it said, I need to know within 24 hours, or I can't hold it open for you for longer than 24 hours. Now, again, if it was an invitation to treat, we approach the problem in a completely different way, but let's assume that there was an offer. Then what happened? She found the offer at this point in time. Is that relevant? No, nothing particularly happened at that time other than she is aware of the offer. Now, we know from cases like Crown and Clark that she can't accept an offer that she doesn't know about. But there's no facts in there that suggest that she was trying to do that. So those of you who were clever enough to have noticed that there is, you know, in this period before she knew about it, she couldn't do anything, it's not relevant to these facts. So you might have noticed that, put it away for later, but that's all you needed to do. At this point in time, she sells to another person. Is she breaching a contract at that stage? No. There is an offer that is open. It's probably a little bit silly to do it without checking her email to make sure that it hasn't been accepted for reasons that I'll explain in a minute. And she would have a problem if it had been accepted, wouldn't she? Because a contract would have been made. But at this stage, there's nothing has happened to accept that offer. It is open. What about the promise to hold the offer, or an implied promise to hold the offer open for the 24 hours? And again, we're really jumping here to look for something to help Zita. We're saying, she said, I need to know within 24 hours. I'm translating that into, I'll hold the offer open to you, for you for 24 hours. Is that an enforceable promise if it's a promise at all? And the short answer to that is no, because of Goldsborough, Mort and Quinn. That's the case. Got it here. Goldsborough, Mort and Quinn. Ridiculous pen isn't working nicely. Basically, any promise to hold an offer open, in order to be enforceable, needs to be a contract. So it needs to demonstrate all of the elements of a contract. There needs to be an offer to hold the offer open that needs to have been accepted, and the acceptance needs to have been communicated. There needs to be an intention that that promise is binding. The words that were used in the material that we got was, I need to hear within 24 hours. That is something short of a statement that indicates I promise to keep it open for you and not sell to anybody else. Third, so that's intention, we've got agreement, intention, consideration. In order to be binding, a promise to hold an offer open needs to there needs to be consideration. Now, we haven't talked about consideration yet. We're just going to talk about it as price for the moment, but no price was paid for that promise. And there needs to be certainty. How long? Well, we probably have certainty 24 hours, but 24 hours from when? It would be, if it's an option, it would have to be 24 hours from when the agreement was made or some other kind of certainty in there. But anyway, long-winded way of saying at that point in time there is no contract, so selling it, there's no breach of contract. Smart thing that she has done at that point. Oh, I'm going to run out of batteries now, just give me 2 seconds to make sure my... Sorry about that. Move to sit down. So smart thing that she's done, next thing she's done is gone to revoke the offer, which she's done by email. Okay, so at what time is so when's the revocation of the offer? When would that be effective?
Is that when she's read it?
I think it's when it's received, isn't it?
Yes.
So it's when it's received. It is when it's received, but because it is an instantaneous communication, received means when it's capable of being read.
Okay.
It's not exactly the same. So let me actually bring up the Act and show you. This is the Electronic Transactions Victoria Act, VIC, proper citation. By the way, for those of you who find cases of legislation in, but it has this really neat little feature over here. Let me just expand it. It basically lets you copy the citation. Sorry, is it? And what it'll do is you can copy it with a link, which I don't know why AGLC4 doesn't want links. Who reads paper? But you can actually copy it with the formatting. So it actually will copy your case names and things from there with the proper formatting for AGLC4. Don't say I don't give you nothing. Anyway, just thought I'd point that out. So what am I doing here? Legislation here. What's important here? Have a look. Definition of electronic communication. A communication of information in the form of data, text or images by means of guided or unguided electromagnetic energy or both. A communication of information in the form of sound, blah, blah, blah. So what we're doing now is an electronic communication, by the way. Very long-winded, not necessarily immediately obvious, but this is broad enough to cover not just email, but do any of you use Slack or Yammer at work, or Microsoft Teams, or you share information over Twitter or Facebook Messenger or WhatsApp, or even in Canvas? All of those things are covered by this kind of broad definition. And then, so let me go down to the section. So let me just do it the easy way. Section 13, time of dispatch. We're looking at 13A, time of receipt. For the purposes of a law of this jurisdiction, so I can show you the Commonwealth Act. The Commonwealth talks about Commonwealth laws, the enactment of Commonwealth laws. So this is broader. So for the purposes of working out common law of contract in Australia, in Victoria, unless the parties otherwise agreed, the time of receipt of an electronic communication is the time when the communication becomes capable of being retrieved at the email address designated by the person, the recipient. So in this particular case, if Susannah sent an email to Zita at the same email address that she sent the offer to, revocation itself would become effective at the time that it was available for Zita to read. So flipping back to our other I really need to stop trying to be tricky and just stand at my desk like a normal human being rather than hurt myself trying to do this. I need to go back to this, share. So at this particular stage, the fact that Zita didn't actually read the revocation until this later time here doesn't matter. Where it's deemed to have happened is back here. In fact, it was revoked before she set the acceptance. Now, if these events, if the timeline had worked differently and these events were here, the answer would have been the opposite. The question becomes slightly different, but let's start with if Zita had emailed the acceptance, I think we're in a situation where Susannah would definitely have had a contract because we've got an offer, it's been accepted, the acceptance has been communicated. The fact that she hasn't seen the communication doesn't matter. It has been communicated at that stage, and the Act would say that it's capable of being read, so it's there. Fax, the next part of that question becomes, well, it's a fax. So is the fax an appropriate method for communicating? Quite frankly, I would say these days you've probably got a significantly better argument today than you did 8 years ago when this problem was written, that, you know, how many of you work in a place that even has a fax machine anymore?
We still have a fax.
Yeah, oh, you work in conveyancing. I think conveyancers are the only ones left.
Really?
Well, no, I'm probably being a little bit unkind, but I'm thinking this is pretty novel for a pet shop to have a fax machine. When you think about how many faxes there were, now when you look at somebody's website, very few businesses have fax numbers anymore. Some of them do, but it's really not as common a way of dealing. But again, it would raise questions. If the fax had been this way around, we would have to ask ourselves, was that a reasonable way to communicate acceptance? We would need to use an objective test. We would look at the behaviour and the relationship of the parties. We would have a whole lot of more questions. But we didn't need to ask them because the facts went the other way around. Questions, concerns, frustrations?
I was wondering if it's a question whether fax is appropriate way of communicating. I thought that might be solved even have fax, then you say it might, well, don't lead you to say, well, it is, but most people might not.
Okay, Stephen, I don't know about anybody else. That was Stephen asking a question, wasn't it? I'm going to need you to go again. It just, you were bouncing all over the place, my friend.
Okay. I was wondering whether fax is appropriate for communicating. It might depend, I would have thought it would depend on whether the person has a fax or not, would help to define whether it's appropriate or not. People don't.
So you're saying whether or not fax is an appropriate way of communicating would depend on whether they had a fax machine or not? In part, yes, and clearly they did. I mean, faxing to somebody who doesn't have a fax machine is fairly limited value these days. It's just going to go nowhere, isn't it? And in fact, it wouldn't, when you think about how the law works, if you send me a fax to my phone number, the message that you're going to get at the other end is it's failed to send. So,
It will
yeah,
So
so,
to get into
and then there's nothing at the server. There is nothing at the device that receives. So yes, they need to have a fax machine, surely, but I think it's probably more than that, because the communications to start off with had been by email. The question becomes, is fax an appropriate way of communicating? And it will depend on the circumstances. You use an objective test. So if the parties had had a conversation face-to-face in the shop, and then Zita's left the shop and then decided to communicate by fax, then machine, that's how they've communicated. They haven't had any previous electronic communications. In this particular case, they've already communicated by email. We don't know what that email says either, because the email itself might stipulate the method for communication. They're the kind of questions we would need to ask. With the facts that we have, we don't have enough information to answer them. And with the facts that we have, those questions become less and less relevant. They're good for us to explore because we're learning about how the law works, but they're not relevant to answering this particular question. And I'm just trying to get you to think about the ways that you will identify the potential issues and ask about them. So at one level, we have completely overlooked that problem. It's a really simple problem. And I think just when you lay it out with the timeline, you see it really is a very simple problem to deal with. But I think it's a great problem to start with, because it's simple, but it does require you to think about each of the steps in some detail, and then actually start to think about which bit of my analysis do I need to include in my answer, and what's sitting under the surface. Now, these questions that are on the discussion board, they're very similar in some ways to exam questions. Actually, the exam questions get a little bit more tricky than this, to be perfectly frank, but you will see that the discussion board questions get progressively trickier as the semester progresses. But they're a really good practice, and I think of them more as practice for exam questions than anything else. And that has shown regularly tend to do better. There's a direct correlation there, and I think that's just practice and getting the feedback. You can see even the way that I've set up the rubrics for them. They're designed for you to answer in an IRAC methodology. So I'm giving you feedback on each of the elements of IRAC plus your writing, and that's what's building your score. And in exams, the marking tends to work in a very similar way to that. If I had an exam rubric, that's effectively what how I approach each of the questions. Have you identified what the issues are? Have you identified the relevant rules? Have you been able to apply the rules? Did you get the right answer? Did you articulate this in a way that I could understand it, structure it in an appropriate way? So that's why I'm giving you the feedback on that. As you get a slightly more complex problem for your assignments, and this is what we'll spend the first half of tomorrow night's class talking about, a large part of what you're also trying to do is work out the best way to articulate that lawyer to lawyer. So a lot of what we'll be talking about tomorrow is how to write a memo, and how to write a memo in a way that it makes sense to another lawyer, and hopefully means that you'll write great memos later on in your professional life, but also you'll get good marks in this next assignment. But again, I hope that methodology for solving the problem, at one level it sort of seems really basic to pull it down to that degree, but I can tell you that when I write complex transaction documents, that's the way I start. I am there working out what are the issues, what is it that my client needs, another colour for what the other side needs, where the negotiating points are, mapping out the story inside the document to work out, well, you know, let's deal with the stuff about setting up the contract at the beginning. Let's deal with the stuff that might happen at the end of the contract at the end. Let's talk about the things about the way the contract will operate in the middle. Let's have the definitions in one place, and we're dealing with it that way. And when there are disputes, you'll find that lawyers are doing something very similar. Now, they might not do it with post-it notes, of course. They might do it with lists. They might just have very well structured brains and be able to pull everything out into a structured list very quickly. But at the end of the day, the guts of what we're doing is very similar.
Cool.
Oh, okay, Stephen, now I can see your question slightly. I misunderstood you slightly. You were saying that does having a fax make it more difficult to argue that a fax isn't an appropriate communication method? Short answer, well, yes, but it will depend on the fax. If I've sent an email to you offering you something and say, I need your reply by close of business tomorrow to this email address, and you accept my offer by fax, my argument that that's not an appropriate communication is just as strong, even if I have a fax machine or if I don't, because I've stipulated the method.
Okay. Thank you.
But they're exactly the things to look at. You're absolutely right. So we're almost at 7:30. We're having nachos at our house. What are you guys having for dinner? No? I feel like I have been talking. Any questions, concerns, frustrations? There were some really good answers. Rita, is there anybody other than Rita here from OUA? Yeah, very small number. The only very small number contributed in OUA. But Rita, yours was quite seriously one of the best I've ever seen. So you didn't have many others to read. In fact, I don't think you had any others to read. But it was you did a really strong job. So I'm not sure that I don't think I've called anybody out on that before. But yeah, you should feel very good about where you were sitting at it. So yeah, on the whole overall, well, yeah, look, and it does tend to be the stronger students who take the time to do them. So there was certainly some good responses. But yeah, I'm going to give Rita the gold star for the day.
Thanks,
Thank you. All right, so unless anybody's got any questions, I will share a recording a little bit later.
one, if that's okay. In terms of problem tasks, is there likely to be overlap?
Rita's always got a question.
Sorry.
Overlap.
Yeah, because I mean, obviously, I don't expect you to give me the answer, but looking at the problem task for this week, I thought maybe I was addressing it wrong because I do see some overlap between the issues in this one and last week's.
Yeah. Yeah, there is. I haven't looked at Buffy since last time, so I can't remember exactly. But when I know all the dicking around with technology at the beginning of this shoot. I can see why you might believe that I just walk into this and just do it. But there's been a lot of thinking about those problems and which ones to put in. And for roughly half of the class at any given time, the Zita and Susannah problem will be the first time that they've done any kind of problem solving in their law degree. You know, for the other half of the class, we'll have done, finished some substantive subjects. Roughly half of the class have done intro, and then this, that and you have to do a problem in intro, but you're doing it in a group as part of your starting out process. And then this is the first time that you write anything by yourself. And it is a little bit confronting because the way that they're set up is you write them and then other people who have written them too can see your answer. And you get the benefit of seeing other people's answers, but only if you contribute yourself. Which makes it very hard for you, Rita, when you don't have other people who are contributing, but we'll work on that. So as a consequence, what I've tried to do is make sure that the problems, that you get the benefit out of doing that. So this first one, then we go through it at this level of detail that I have today, and the feedback I give you, I hope, was intended to be as constructive as it can. And then you've got another problem, and you can then look at what you did last time and this problem without it hurting your head too much to see how you can push that to the next level. So as they grow, they do get trickier towards the end, but they're not, they're not sheep station tricky. Like they're designed so that you should be able to do them relatively quickly and be able to practice the craft of writing a response to a problem.
Okay, cool. That's really helpful. Thank you.
So, yeah, because you end up second guessing yourself because you think, well, this is the answer that I had to talk about that last week. But it's an interesting thing in a way too, because actually at this stage you don't know very much. You know a lot, like clearly you've got a whole undergraduate degree, many of you got other postgraduate degrees behind you, you're out in the real world, you're doing stuff all the time, but when it comes to this subject in contract law, you actually don't know very much yet. You've only just started thinking about it. So that limits what I can ask you about too. So we build on it though.
Okay, great.
The other thing too, I think most people come into contract law expecting that it will be just ridiculously hard and boring. And it's actually neither of those things. It's particularly not boring. Well, in my view. And if you find it really mind-numbingly boring, well, I like to hear from you, but I also think it's just like, well, if you really don't like the kind of logic skills that you need to use in a subject like this and the kind of writing practice that you need to do in a subject like this, you probably will not enjoy being a lawyer, the actual doing of legal work.
Yeah.
And look, I get it. Not everybody loves their job every day. I certainly don't. But it is worth thinking about that. But it's funny, like I think I get the best subject because people have such low expectations of it. I think the only one that people have lower expectations of is tax. So I'm not even sure you have to do that anymore. Okay, on that cheerful note, and with the smell of nachos wafting from my kitchen, I will see many of you tomorrow night. The rest of you will hear my dulcet tones within 48 hours after that. Thanks for your time.
Thank you. Enjoy your meal.
Thanks, guys.